All right, everybody, welcome back to Better Call Paul. We have Paul Krasker in the house. Today, we're going to talk about a not so fun topic, but we're going to talk about deceased clients. And this, of course, being that we're in South Florida, is something that we see a lot. And I did get a funny email response back to this saying, is this class going to be teaching us how to bring them back to the dead and make more money off them? And that, of course, is not the goal, but it did make me laugh. However, what we want to do is kind of get Paul's strategies on best way to go about working with clients that have already passed, and maybe some tips and tactics and best strategies for working with clients or family members that we know somewhere down the line are going to, and the correct steps and what it takes to get through probate and all that fun stuff so that you guys can get your listing sold as quick as possible. And if you're on the buyer side of one of these deals, you have the best chance of success in a realistic time frame. So Paul, take it away. We'll leave it for questions at the end, but let this go whatever direction you think.
Well, it's interesting when you're talking about deceased clients. I assume you mean clients who pass after the contract and before closing and how to handle that. But it sounds like you're also lumping in people who have who have died, and their heirs are trying to now liquidate their assets.
I think a little bit of both, if you don't mind.
Sure. So the first thing to do is to figure out exactly how the property is being held in title. Is it held in a trust? Is it held in the individual's name? Is it held with joint tenancy with rights of survivorship so that there's somebody else on the deed and all you have to do is record a death certificate? Is it held as joint tenants in common, or tenants in common rather, in which case you're going to have to probate the decedent's half of the interest. So you really need to understand how property is being held. Once you determine that, you can come up with a quick strategy to liquidate. The other thing you need to know up front is this homestead property of the decedent? It's very, very important up front to know, is it their homestead, is it not? There are very specific rules in the state of Florida as to how you can devise homestead property. If it is homestead property, then we have to go through a litany of other questions to figure out who the right person is to transfer this property. If it's not homestead property, it becomes easier, and we know we have to do a probate if it's not held in a trust or held jointly with rights of survivorship. But again, if it's homestead property, even if it's held in a trust, there still may be other parties who need to be joined in the sale and who need to sign documents. Is that sort of the speech you were expecting me to give, Ryan? Or?
Yeah, that was definitely it. And I think just also going into it, knowing as a listing agent, we're seeing this happen all the time, especially now. It might be a little bit more difficult because people's lack of ability to travel. And I know things are opening up, but maybe there's a family in the Northeast that has had a relative pass away in a property down here, and now they're trying to just go through, the right order of getting this thing done. And a lot of times we see the agents kind of jump the gun, and someone calls them and says, hey, I have a property to sell. And they get over there in, 7 minutes and get the thing listed, put it on the market. And then we find out 2 weeks later, hey, this is not going to be a 30-day process. So, you kind of explained what they have to do. What does the process look like, I guess, before they list it? But also, let's say we're working with an agent that runs into that. What's the best way? Do they just connect them to you and you guys go to work? Or, what's the way to get it from point A to close as quick as possible?
Yeah, that's the first thing that we suggest. Reach out to me. I'm happy without charge that I am going to tell you at least the process that needs to go forward. I'll give you a general sense of what it's going to cost. We do this all over the state, so we're certainly happy to be involved in getting it pushed forward. And then at least they'll know what's going to happen if the estate or the heirs choose somebody else to do it. That's their issue. But for the agent to understand what needs to happen and why. And a lot of the times you get clients who don't listen to you, who say, we're not probating this. We'll just give them a quitclaim deed. Okay, that might not be a file you want to be involved with at that point. But the other piece is upfront for me to let you know who you need to talk to for the listing. I mean, I've had horror stories with people spending $3,000-4,000 of their own money in expense in starting to market a property that they had no right to market. So that's another reason to reach out to us upfront.
So when these things do come up, I know you can't tell because every case is different, so I don't want to hold you to a number, but if you get it in the right time, what does the time frame look like from the day someone says, hey, I do have deceased parents, clients, friends, whatever, looking to sell the property, I'm going to give it to you ahead of time. How long can it take to sell this thing? When should we put it on the market? Do you give us the go ahead, or do we put it on and say can't close for 60 days, 90 days, 120 days? What can we expect? Again, knowing everything could be filled with curveballs, but.
So if it's homestead property, I tell people set a closing date 120 days out, because you have to go through the creditor period, and that's going to be a 90-day period after filing notice to creditors. So I always tell people, give me 30 days to get the death certificate, to get all the paperwork filed, and then I need a 90-day period to run. If it's non-homestead property, I'm comfortable telling people, give me 30 days to get the estate open. As long as the clients are going to be cooperative, as long as they're going to give me a death certificate on a timely basis, I can go in and get a court order to sell it. Now I have to hold the proceeds in escrow for the creditor period, but at least we can sell the property. And from all of your perspectives, you can get your commission paid at closing. And the only people who have to hold those net proceeds are the estate. And the estate should be happy to do that, because they don't want to own the property during hurricane season. They don't want to continue to pay association fees, taxes, insurance, etc.
Yeah, and the fear of the market, right? I mean, obviously, right now we're going in the direction where it's going up, but like you said, there's no fear in having the money locked in escrow, and then after that 90 days, then it's yours. So really, the big question to make sure every time they're asking is the property homestead. That seems to be the factor that's really changing it from 30-ish to 120-ish days.
Correct.
Got it. Anything else that they should know about this process? If you're a listing agent, are there specific documents? I know you've said death certificate at least a couple times already here in 10 minutes. Is there anything else specific that they need to make sure they get or find or track down?
So if it's held in a trust, you want to see the trust. You want to see the trust and all amendments to the trust. And I've had horror stories, personal experiences with people who just lied to try to get the property sold. And eventually, when it gets to the title company, we're going to require it. So you guys should say, if you don't want to send it to me, happy to have you send it to the title company that I recommend to close the deal. But somebody needs to look at the trust and make sure that you guys can really sell, because you don't want to be in default of a contract at the 11th hour. So the copy of the trust, if it is held in a trust, and then just a general sense of who the beneficiaries are.
Makes sense.
Are there 12 kids?
Yeah.
When you always find out, they say, oh, there are only 4 of us. And then the truth is there are 5, but they all hate this one guy who won't talk to anybody. He's been in jail twice last week, and who knows where he is now. But
you still have to be able to track him down.
I still have to get a signature if it's homestead property and he's one of the children, and they're required to sign a quitclaim deed. If I don't have them, I've got to file a quiet title action, declare him missing or whatever it is. But yeah, we need to know that, and you need to know the truth up front. So
Makes sense. Anybody, any questions on this one? I mean, I think it's pretty straightforward. We're looking for trust documents, we're looking for death certificate, we're asking about homestead, and we're getting this thing referred over to Paul as early as possible. Just on the flip side, I know this is kind of morbid, but let's say we're working with someone where they know the family member or the client is close, right? We've all kind of ran into those. And if you haven't yet, you will, where they know somewhere in the next, whatever, 30, 60, 90 days, maybe even a year, this is coming. Is there certain steps to make sure they take while the client is still alive, power of attorney or the trust, or getting you certain documents? And is that too early to tag you in to start prepping? Or is that, being over?
No, and sometimes that can be a blessing for the family. And I've done a bunch of that recently, where I meet with the parent and we do a life estate deed, keeping the property in the mom's name, but having it automatically transferred to the two siblings upon her passing. And all we needed is a death certificate. We didn't need to probate the estate. And we were able to close 30 days after her passing, and with no expense for probate. So they spent maybe $750 with me up front, drafting 2 documents and recording those documents, and it saved them $3,000. So I'm happy to do that in advance with anybody who has that desire. And I've also said it a couple of times on these calls, the other thing not to be involved with is people telling you that they want you to draft a quitclaim deed. If you draft a quitclaim deed for a mom to her 2 children, and she passes away, and then the kids go to sell that property, you're going to get sued at some point in the next year, because they're going to go to their accountant, and the accountant's going to say, well, you owe capital gains tax based on mom's basis in the property. And if you just let her pass away with the property in her name, you wouldn't have had to pay any capital gains tax at all. And sometimes that could be a $90,000, $100,000 difference in taxes. And if you at all participate in that, they're going to deem you to be a real estate professional, and they're going to sue you and collect the tax liability. So don't help them with a quitclaim deed. Bring them to me, let me do a life estate deed, or let me do a trust, and a waiver of homestead. And those are the kind of things that will save them a lot of money down the road.
I can't even imagine that a realtor would think of doing that, but obviously it's happened because you brought it up. So that's always fun.
My next door neighbor in my old house leaned over the fence to me one day and showed me a quitclaim deed that a local realtor had prepared at her children's expense. And she asked me whether I should sign it or not.
Oh
And
my God.
I responded with, do you like your children or not? I couldn't believe it. And the realtor was shocked to not get the listing when when my neighbor passed away. But they gave such bad advice to the kids. Yeah.
That is wild. I guess the more you talk about it, I'm sure probably happens more than we'd all want to know. But.
Yeah, and that would have been $120,000 liability. Yeah.
Oh my God. Imagine waking up to that thinking you're getting 500,000 between 5 kids and you're really getting whatever, 380, and you already had that money spent, because that's what we do here in America.
And when the realtor asked me about it after the neighbor's passing, I said, don't feel bad. Think of it that you actually saved yourself $120,000.
Yeah, that's true. Very, very true. All right. Anybody, any questions for Paul about working with deceased clients? Give it a couple seconds to see if anybody jumps on. And if not, I want you guys to mark your calendar. Next week, the 8th, we're doing escrow disputes. And the week after, the 15th, we're doing different kinds of deeds. Question in the chat: how do we work with HOAs that have taken homes of the deceased because of outstanding unpaid fees?
So if a HOA filed a claim of lien, if they want to foreclose on that claim of lien, they have to appoint a guardian ad litem who searches for heirs. And if they find heirs, they have to notify the heirs that you have a right to step in, pay the association fees, and probate your estate and take title to the property. And if the heirs don't open a probate and don't do anything, then their interests are foreclosed out. And the association then owns it over the interests of the prior deceased party.
Got it. Anybody else? Any questions? Going once, twice. Oh, what? Wait, one more. Friend, potential client for you. What's the best way to get a hold of you? Just tell me the number or the email and I'll type it in the chat.
Yeah, so Pete Krasker at kraskerlaw.com and 561-515-2929.
Perfect. Guys, I threw that in the chat. I'll leave it up for another minute here once Paul gets off, just so you have it if you need it. But the email and the phone number are in the chat. Anybody else? All right, Paul, good to see you as always. See you soon.
You too.
Thanks.
Hey, Michael.
See you guys.
Thank you.
Later, guys. I saw someone ask for the recording in the chat. I just put my email in there. Just send me an email, and whenever I get it, the recording done, I'll get it to you. All right, all. Have a good day.